extradition framework. The Extradition Act provides for extradition on the basis of principal dual criminality for offenses punishable by a sentence of 6 months imprisonment or more. South Africa can also extradite its own nationals. All extraditions must be consistent with the South African Constitution. For example, South Africa will not extradite if capital punishment were to be imposed. Madam Chair, South Africa has signed extradition and also mutual legal assistance agreements with some of the members of ALCO. It is also a party to EU Convention of Extradition. It should be noted that extradition is not dependent on any treaty. Under Section 3, subsection 2 of the Extradition Act, the President may, in writing, consent to surrender a fugitive. Under Section 3, subsection 3, fugitives may also be surrendered to countries which have been designated pursuant to that section. Having said that, Madam Chair, there are challenges encountered in implementing pertinent provisions of international legal instruments. With respect to extradition and mutual legal assistance, the problem experienced in most countries are that the process is too lengthy. The international community should look at simplifying international cooperation procedures to ensure speedy finalization of extradition and mutual legal assistance matters. With reference to the question of overcoming obstacles in exchanging information through mutual legal assistance, there is a standard procedure that is followed when dealing with requests for mutual legal assistance, namely exchanging information directly between central authorities through diplomatic channels. In conclusion, Madam Chair, it would be ideal if member states can establish central authorities in the jurisdiction of the respective member states with a specific intention of expediting the process of request in instances where the request is urgent. I thank you.
Thank you, South Africa. South Africa was the last on my list. Is there any other member state which wishes to take the floor? China, you have the floor, please.
Thank you, Madam President. First of all, I would like to thank our panelists for their clear and thoughtful remarks. And I also want to thank the Secretariat for their preparation of the report of this session. We all know that the LC plays a very important role in promoting the rule of law at international level. So in this regard, I want to express our appreciation to the work of the LC and all its members, both current members and the former members. I think that ALCO also, the Secretariat of ALCO also deserved the commend for their regular communication with the IRC, and we think that it will helpful to promote the involvement of the Asian and African states in the lawmaking process of international law. Madam President, I just want to take this opportunity to make very preliminary comments regarding to 3 topics under the current consideration of the Commission. The first one is the immunity of state officials from foreign criminal jurisdiction. We note that the Special Rapporteur has submitted her second report, and in this report, she correctly limits the scope of this topic to the immunity of state officials from criminal jurisdiction of a foreign court, while excluding the immunity of state officials in international judicial institutions and excluding immunity of specific groups of officials such as diplomatic and consular officials, which are already covered by relevant conventions. We just support this kind of limitation. As to the scope of immunity rational personnel, we hold that that is the international community's consensus that the heads of states, heads of governments, and foreign ministers, the Troika, enjoys immunity rational personnel, and the immunity is an absolute one without exception. However, we think that international practice does not rule out the possibility of granting immunity rational personnel to other high-ranking officials of a state. If we probe into state practices, it may be observed that many cases in national courts have demonstrated that immunity rational personnel for officials is not limited only to Troika. And we can also say from statements made by states at the 6th and 66th and the 67th session of the 6th Committee that many countries agree to explore in varying areas the scope of immunity rational personnel, so that we're looking forward to the further study on this issue by the Commission. Second, on the topic of formation and evidence of customary international law, we appreciate the first report submitted by the Special Rapporteur, Dr. Michael Wood. The Special Rapporteur defined the scope and the outcome of this topic and made a very thorough review of research materials in a very clear and open approach. In our opinion, the criteria on the formation and evidence of customary international law should be a unified system applied to all situations. There should not be different criteria for different branches of international law or for different audience. Regarding to the youth organs, we agree with the Commission that the youth organs and the customary international law are just different legal concepts, and they are not necessarily connected. So we agree with the decision of the Commission to not tackle the issue of youth organs in this topic. We believe that it is more helpful for the Commission to focus its resources on the relationship between customary international law and treaties and customary international law and the general principles of law. As for the outcome of the topic, we support the idea that for this topic, we should strike a balance between the certainty and flexibility. We think that perhaps unified and clear guiding principles may serve this purpose. We also agree to change the title of this topic to Identification of Customary International Law, which we think could reflect more appropriately the substance of this topic. The third topic is the protection of persons in the event of disaster. We note that the Special Rapporteur of this topic in his sixth report expand the scope of this topic from the response phase to after the disaster to the pre and post disaster phase. We agree to this expansion because we highly value the disaster of prevention, mitigation, and preparedness in the disaster management. At the same time, we are of the view that the Commission should note the differences between natural disaster and man-made disasters, and states who suffered from disaster should not be obliged to bear too many responsibilities with regard to unpredictable disasters. In this regard, we agree with the comments made by Dr. Pereira that for this topic, it would be better to provide guidance for international cooperation and enhancing the solidarity of international community rather than impose obligations or duties to the state which are suffered from disasters. Those are the preliminary comments we want to make at this stage, and I thank you very much, Madam President.
Thank you, China, for your comments. I don't see any further requests from the floor. Okay, Iran.
Thank you, Madam President. With your permission, I wanted to ask two small questions and one proposal. Two small questions from Mr. Michael Wood regarding identification of customary international law. The first question is, do you think we can accept resolution of the international and regional organizations in the same level as a state practice? In other words, do these resolutions have the criteria of being customary international law? And second question, with the permission of Professor Mumtaz, I want to repeat his question regarding the separate and dissenting opinions of the judge of ICJ. Are they in the same level of the judgment of ICJ itself in identification and shedding light on the customary international law? And that's these two questions. And my proposal, may I ask Mr. Michael Wood to convey the message and opinion of the majority of ALCO's member states regarding the expanding the scope of rational persona and immunity of state officials to more officials than Troika. The discussion today showed, and it was the benefit of having the meeting between ILC meetings and Sixth Committee in the New York. We could have more discussion here and show our position and exchange the views, and then we can have our views in Sixth Committee, which have been discussed here. It is the benefit of having this meeting in between of ILC and Sixth Committee. Thank you very much.
Thank you, Ran. I'll give the floor to Sir Michael Wood.
Well, on your last point, of course, I think the views expressed at this meeting will be well known to the members of the International Law Commission. You do a very good report of the meeting, and we will be reading it. I agree with you on the timing of this meeting. The timing is good. It would be even better if you had already the report of the International Law Commission, and perhaps on another occasion, if you have a similar timing, you should make efforts to try and get an advance copy of the report. I have an advance copy of the report, but it's difficult to get hold of it. Your two questions. Firstly, I apologize for not responding to Jamshid's question about dissenting and separate opinions. I think my answer is is that, of course, I wouldn't give the same weight to dissenting and separate opinions